May I participate? May I participate? Item 2 of today's supplementary list. I seek next week, 21st, because that file, looking to the bulk of the file that was entrusted to me yesterday. I am for the state in that case. I have informed my honored friend for the that is coming. He of course told me that you kindly wait, let it reach.
Mrs.
Let
Modi
it
is
reach.
there.
I will make the
Item 2 maybe. That's complete. It will taken up item 2.
He told me the same thing. Let it be taken up.
So they will take advantage of your unpreparedness.
No. After 4 or 5 sentences, I will try to.
See, it was told to us that you have already been interested. So it is up to you.
Yesterday night, looking to this.
So କଣ କରିବା ପଢିନାହାନ୍ତି ସେ ଆସନ୍ତା ସପ୍ତାହରେ ଆସୁ
Let the matter reach you.
Let him come.
Yes. Interest of client at least. Let it reach. In the interest of client, let it reach, then only we'll see.
That would be more in the interest of the both sides, not of the client. Not permitted to make a mention. Item 62 on your lordship's board, weekly board. Maybe subject to the lordship's convenience.
First take up item number 1 because the voting is that supplemental which will be taken out last.
Yes.
So wait please.
Wait, please. I mean, yes. May it please your lordship. Your lordships had referred to the last order of 1st of March 2024. And the learned Advocate General was interested with the matter to find out an amicable solution. Now, this becomes important in the light of one of the orders that your lordships will be enough to just peruse. Kindly see order dated 2nd of January 2024, because this order was passed in the light of the observations and the made in the order dated 2nd of March 2024. Sorry, 2nd of January 20. But this is written 26000 of 2017. May I read it?
Yes, sir.
The matter is being taken up to hybrid word learned counsel for the parties. Reply affidavit filed on behalf of the opposite party number 1 in the court by serving so and so. In the reply, para 10, it is stated. Therefore, the prayer of the petitioner for grant of additional 6.64 hectares of contiguous adjoining land is not possible after the introduction of the so and so, so and so, so and so. Mr. Sharma, learned senior advocate appearing for the petitioner, vehemently contended that the taking a different stand at different points of time, though the case lies in a short compass, which has been clearly indicated in the order of this court dated 29th of June 2022. Mr. Mohanty, learned advocate, additional government advocate, contended, this is the crucial part, contended that there is a mistake on the part of the state by giving such lease boundary, but the same has been seriously objected. Mr. Sharma contended that such a mistake of a lease is raised only after 8 years, which is not permissible. As such, if any area is mentioned in the lease, then the parties to the lease agreement should adhere to the same. Since the petitioner has discharged its part of the obligation by depositing the required fee, the question of wriggling out from the position of the state does not arise. In any case, Mr. Mohanty wants to file further affidavit. Said this is unusual, for the state to have owned up a mistake on the face of the record. But before that, there is a order, which will set the perspective of the case. If your lordships will kindly have 29th of June 2022. And it just take 2 minutes, Malad, then I'll leave it at that. I know the learned advocate general is here. Lordship will get an overshot of the whole thing.
Which order?
Malad, it's 29th of June 2022.
2020.
2022, Malad. 2022. 2022. 29th June.
Yes.
I'll skip the first paragraph. The petitioners filed this writ petition seeking direction to the opposite parties to deliver the actual shortfall mine lease hold area as detected in Annexure 5 within a stipulated time, and further seeks direction to the opposite parties to deliver the shortfall of so-and-so within a stipulated period. So-and-so, the petitioner contended that pursuant to the supplementary lease granted in favor of the petitioner entered into an agreement with the state opposite parties wherein the area has been prescribed as 45.932 hectares along with the description detailed therein, and for that purpose, stamp duty and anticipated royalty has been received to the tune of so-and-so, besides other dues. It is contended that the petitioner has complied with the terms and conditions by depositing the requisite fee as has been stated. Therefore, the authority should have delivered the very same area, that is such and such, in favor of the petitioner as has been agreed in the agreement. But by virtue of the consent order dated 16/12/2021, this is also important, passed in writ petition such and such, it has been directed to the Director of Mines to place on record along with an affidavit before this court the 2016 DGPS report submitted by the joint survey team demarcating the mining lease areas of the petitioner opposite party 4, opposite party 5, not later than 1/2/2022 with an advance copy. In compliance of the said order, an affidavit has been filed by the opposite party, that is the state, incorporating the map which indicates 29 hectares of land has been allocated in favor of the petitioner. It has also been brought to the notice of the court Rule 33 of the concession rules, which states about the survey of the area of the lease, provided that when a mining lease is granted by the state government, arrangements shall be made by the state government at the expense of the lessee for survey demarcation of the granted under the lease of the survey area lease to be conducted by the total station differential global positioning system. Further, since 8A6 of the Mines and Minerals Development Act provides that if the lease has been granted for a period of 50 years subject to a condition that all the terms have to be complied with, the petitioner is entitled to get the leasehold areas by virtue of the agreement between the parties. To substantiate his contention, he has relied on the judgment of this court of the apex court in Ashok Kumar Lingla versus State of Karnataka, which states it is unnecessary for us to go into the validity of any previous demarcation. It is obvious that when large areas are granted for mining purposes, some confusion as to the boundaries, especially if they are adjacent to each other, is nothing abnormal. What in such cases needs to be done is to conduct a fresh demarcation, fix the boundaries so that the parties holding the areas stay within the limits of their respective areas instead of straying into the adjacent area. The petition provides that the petitioner has to be given 45 hectares. As such, the map shows that the petitioner has been given 29 hectares. Admittedly, there is a shortfall of the area so far as the lease is granted. Therefore, this court directs the opposite party to file an affidavit with regard to the shortfall areas as has been indicated vis-a-vis the map filed list after 2 weeks. Then, my lords, they take a different stand that no, this. But be that as it may, now the point is, my lord, that there was some area which we pointed out to the Honorable Court in the first instance, about 6.69 hectares, which is adjoining. So, my lord, this Honorable Court, my lords, referred, because we also don't, my lords, wish to slug it out. So, therefore, my lord, the offices of the Advocate General were requested, my lords, to find out an amicable solution. Your Lordships have kindly recorded, my lords, that the parties sat together. The learned Advocate General is here. His good offices, my lords, will be used. Whether there is an agreement, whether there can be an agreement, whether there can be a via media, but it has to be sorted out one way or the other. If not, then your Lordships will hear the parties.
Any communication from the side of Advocate General to your office? regarding amicable settlement. Any communication from the side of Advocate General to your office for amicable settlement?
No, my lords, not so far. Not
There
so
is, yes.
It's a relevant order, that is 1st March 2024.
March 24.
Yes, 1st March 2024.
324.
In which WPC?
WPC 26000.
Okay.
Of 2017.
Hmm.
There also can come to paragraph 4.
Yes, who is to initiate?
Six of such reply affidavit filed by OP number 1. All parties have agreed to sit together and explore the possibility of amicable settlement of the dispute between the parties outside the court. Next, will automatically come to the order dated 23rd July 2020. That my lords are passed.
This is only a reiteration of that order.
Yes, it is. Only to take instruction, as because in the meantime, the Advocate General has been chaired, and then train was has already informed the Advocate General. That's because we need some more time to have a sit with the learned Advocate General, and he may address this case.
No, that was also the submission which was made on 23/7/2024 that new Advocate General has joined yesterday. That means on perhaps on 22nd, and some he has to apprise us about the developments so on. So what the learned senior advocate Mr. Sarma says that he has not received any communication or any date to sit together and to have a negotiation or for
Just to appraise your lordships, since I as a party, I'm the respondent.
yes, sir.
There was a sitting.
Please adjust that mic.
Oh, sorry. But there was, pursuant to a lordship's direction,
Yeah.
earlier direction, there was a sitting in the learned Advocate General, former Advocate General's office, and the petitioners and Mr. Chetan Sharma and his clients, and we were also present. And there was a discussion, and the government officers had also been at the learned Advocate General, and they were saying, because as your lordship knows, the case now is that whether an area of 6 acres unutilized can be given in
Right.
lieu of the fact that there is a shortfall.
Right.
That is now the issue.
Shortfall is admitted.
Shortfall is there.
Yes.
Now, we are shortfall is not an issue, my lord. Shortfall is there, but my lord, I'm not addressing anything on merits now, because so far as we are concerned, we are within the boundaries. I mean, we are not in excess. But by chance, he has a shortfall according to the lease deed. Whether initially, in fact, at one stage, the court had explored the possibility that should we return the amount you have taken extra, so direction to that effect.
Yes, yes.
Then there was a second direction that whether this shortfall could be given. The government, because the government also gave an affidavit that in view of the new law of the Mining Act, we cannot give it as such because it has to be auctioned. That was the stage when this settlement issues came up. Now, the settlement issue, there was a discussion. What is the outcome of those discussions after that? Because we are not privy to that. It is for the government to decide whether they can consider, not consider, and we are not privy to that. So, government went to a London Advocate General because they knew that is given back. There was a discussion, but there is no result. Has not.
What he said that
This is precisely what I am saying, but it may not be confined that there is only 6.69 to be given. The shortfall has to be given. But as a via media, in the first instance, 6 can be given. It's not that 19 has been given up for 6. But I'm not pressing the fact, because once we explore a settlement, there is a give and take. There is a give and take. But we come to a reasonable middle ground. That's the point.
has been submitted. It is that settlement is not possible. Then the matter has to be adjudicated on
Then,
merit.
then your lordships will adjudicate them. Because also, my lord, your lordships will bear in mind, there is an order of the Honorable Chief Justice.
No, it's just between the state and the petitioner, because we are not.
That is exactly because
So if they can.
the problem is that new AG has joined
Yes,
and he
true,
is
true.
No problem.
If
We'll
if
fully
they can-
cooperate. In fact, my lords, it would be better and discreet if all parties are called by the learned Advocate General, my lord. We'll again sit with him. the
Mr.
officers can be called, and if a settlement is possible,
Mr.
very well.
Sharma,
If not, we'll argue the matter.
address your lordship, no more required for this sitting. There is already.
Sharma, the question is that whether that 6 acre or something
Can be given
to give to you or
not.
The main thing. So their presence
I
may
will-
not be necessary.
No, that's
If
within
it
the
takes a-
agreement of state.
Milord, it may not be 6 acres. It would be a wholesome settlement now, because 6 was at
No.
that time we said it was it no. It was a suggestion put forward when the predecessor division bench was in session of the matter. It came to light that there was about 6.69 hectares available. So Justice Sarangi then Milords observed, very well, at least this much you can take, then we'll see. It's not bound down to 6 acres only. So if it is, it depends upon.
That part is set at rest after the affidavit is filed from the side of the government, saying that after the change in law, it has to be put in auction. That is how the question of to explore the settlement. It is because
No,
office.
With utmost respect, it may not be that, because this is a auction which has already taken place. This is an auction taken place. You have to abide by that auction. You can't have. So therefore, Malad, therefore, the state has candidly accepted its mistake. Now, if with this question, still we are saying we will go in for a settlement if there is. If not, your lordship will hear the matter.
Yes, lordship will hear the matter. Lordship possibly can direct as a last chance. Let the state come back to your lordships. Is there the solution suggested on behalf of the state or not?
For this time,
Maybe that
submitting that the AG has to take some further time.
Yes.
Because
that your lordship. Otherwise,
what I found just now was in the courtroom was probably there may not be any amicable settlement.
no question between us. It is you and the state. Him and the state.
Either by way of an affidavit or something.
Yes.
Just give that.
That is not possible.
Disorder, that is not possible.
That's
we can
because
the matter on
was explored.
Because of the order that was passed by the division.
It's explored.
Clear. That is why we adjourned also the matter last time. And you said that is a genuine, of course, that the new AG has joined. Some time may be required. So now you say some further time. So it's all right. But you mean to say this should be the final and no further adjournment. That is also recording this.
Yes.
So could I only? I mean, I'm just not respectfully floating this, because the previous Advocate General Malad, he was apprised of the position. Now it may, and I am saying so, Malad, that the opposite parties may also be called at a date suitable to the Advocate General.
Don't agree.
Let us put our points together for the first time, because the current Advocate General has not heard us. He has not heard the opposite parties also. So let that mini exercise be done. Then whatever has to be done has to be done.
Totally. For us, it's that we are not in excess. So Lordship only said
not possessing the excess land. It is the government who is possessing.
Yes, but they're wrong.
Whether they will give it or
they will give the land. They will give or return the money.
Go and
We're not concerned.
Right.
So Lordship.
They do taxi and
Yes, sir.
decide for that.
Yes. Lord may direct the state to come and affidavit in terms of the court direction. Is anything has been found or not? Let them conclusively say yes, no. If the learned petitioners council will meet the advocate general by his own, we have nothing to say, but not with us.
1-3, the first order was passed in this respect. 1-3-24 regarding that. Right?
Yes, sir.
And that area we have to record it. Where is that area mentioned, that 6 acre or where it is mentioned?
That I don't.
Somewhere it is mentioned, Mr. Dharma also. And senior advocate pointed out that some
29,
29/6/2020.
29/6/2020.
Number 6 Then. It was 6 acres.
Double petition number 2600/2017.
We are
No. 6 acres is not there in that.
No, that was initially a proposal from the side of the petitioner, because that land is lying adjacent to their land.
That was a proposal, interim proposal without prejudice to the rights.
There is no order.
There is not 2/124. No, there is a 6 acres one.
Well, in which order that 6 acre, etc., has been mentioned. That is exactly we want to know.
See, you affidavit.
Yes, exactly.
But
After the
my friends are right. That is in order dated 5/5/23.
5520.
My friends are also right in saying that this is a proposal which came from our side. It has been so noted.
5520.
But that, Malad, I assume that the state has said that it is not available. After that, now this is May of 20. After that, Malad, these orders have been passed. So now to relegate the parties that only you go by whether 6 is available or not would be setting the clock back, and all the orders passed thereafter, Malad, will be rendered not. So therefore, what I am saying is, if the opposite parties want to place their case, they are most welcome. If they don't want to, then please, Lord, it's my request that the spirit and order of the Lordship's order that the Advocate General will hold a meeting so that he gets a grip of the actual situation. It behind closed doors, Lord, that the officers tell him very well 6 is not available, an affidavit is filed, 6 is not available. That puts paid to all the effort of 2.5 years of this honorable court. That can't be. That should not be.
We heard Mr. Chetan Sharma, land senior advocate, appearing for the petitioner. Mr. Chetan. Which was the order last time? Asha. Mr. Ashok Mahanti, land senior advocate, for opposite party number 4, no?
yes,
And Mr. Padi, land senior advocate for opposite party number 5.
Sir.
Mr. Janmejay Katkia, land and additional government advocate. During course of argument, Mr. Katkia pointed out the order dated 5/5/2023, passed in WPC number 26000 of 2017, in which Mr. Sharma and senior advocate appearing for the contended that 6 hectares of leasehold area is available, and if for some reason or other 16 acres of land cannot be compensated, then 6 hectares of land which is available adjacent to the mining lease area can be given to the petitioner. On such submission, the land and additional government advocate took time. After, the matter was adjourned from time to time, and it appears that when the matter was taken off on 1/3/2024, an order was passed 1/3, basing on the reply affidavit filed by the opposite party number 1. Parties have agreed to sit together and explore the possibility of amicable settlement of dispute between the parties outside the court. And accordingly, this court permitted the land and advocate general as well as land senior advocates appearing for the respective party to sit together and come up with a solution so that the matter can be disposed of accordingly. On 23/7/2024, when this matter was taken out, adjournment was sought for by the Land Council for the state on the ground that the new Advocate General has joined on 22/7/2024, and it will take some time to apprise this court regarding the development made as per the order dated 1st March 2024. When we made a query to Mr. Sharma the learned senior advocate as to whether he has received any communication from the learned advocate general, uh, any date for discussion regarding the settlement. He said in no. The London additional government advocate submitted that some more time is required to comply the order dated 1/3/2024. Though in that order there is an observation that all the parties should sit together and explore the possibilities of amicable settlement. The London senior advocate appearing opposite party number 4 and 5 submitted that since the matter is between the petitioner and the state government, whether the state government would allot the land of 18%. 1, 3.
6 hectares.
No, very in that order. What is that order? 6 acres.
6 hectares of land.
6.5.
Why are you going to here and there?
That is in 1/3.
Okay.
1/3 is the water.
No, 5/5/23. No.
5/5/2020. Around, you also can say around 6 hectares. Without
5/5/2023. It is between the state and the petitioner whether the state would give such land to the petitioner or not. The presence of the opposite party number 4 and 5 may not be required. Since the Learning Council for the state is asking for some more time in view of the fact that new AG has joined, as a last chance, time is granted till to date. So that was fixed. A date is to be fixed so that on that day you will file an affidavit and say whether it is yes or no. Then we will commence the hearing from that day. Please tell us, Mr. Sharma, please tell us a date next month so that from that day either yes or no we'll start the hearing on merits. Please unmute yourself, Mr. Sharma. Please unmute yourself.
Statement.
Just a minute. Please.
Lordship,
okay, now we are able to.
Yes, I am. But I was just thinking, subject to your lordships, because 2 weeks your lordships have said, and rightly so, that the matter will proceed. Either they say yes or no. But before that, my lord, if your lordships before that date, not after that date, before that date, if the opposite parties don't wish to, let them not. But at least we can put the perspective before the learned advocate general so that he has a better view of the matter. Otherwise, it will be a closed affair that the department will say, Saab, we don't have 6 acres, and the matter will then get constricted only on that point. When an amicable solution is to be taken, my lord, let the advocate general have a full view of the matter.
Obviously, communication will be made from the learned advocate general office to you. And obviously thereafter it will be done. But now we are concerned with that particular date, which all of you, if you agree, we can fix it on that day. But that just we want.
Is it
23rd
September. If it could come in the order that the is at liberty to call for a meeting, that will help matters.
I think I know just about the background of the cases.
Yes, but
let them do so. It's open for them. It's open. Let there be a code order for that. Let there be a code order.
Proposal that is, or the date which has been suggested by the Learning Council for the state is 23rd of September 2024, which is Monday.
the meantime, they can whatever. It's open for them.
Very well not. In the meantime, your lordships may say that the Advocate General may explore in terms of the previous order.
It is that
On 23rd September 2024, on consensus lecture of all the party, the date is fixed to 23rd September 2024.
But there would be a slight caveat here.
That was your contention that
No,
it
no,
was
no. Well, my contention. Bear with me for a minute. Well, that was a contention at that point in time when we said that 6 acres is available. To which the learned.
The matter has gone to that for amicable settlement.
No. It has not. It has not gone on 6 acres. It has after because they said no, 6 acres is not available. Then, Malad, no, they said it is not available. We said as a interim measure it is. But let's leave that aside. Then, Malad, the wholesome settlement was there.
Till now, nothing has come stateside whether that 6 acre is available. 6 hectares, sorry, 6 hectares of land is available.
They had told the court it is not available. They had told the court. Thereafter, these orders have been passed. So thereafter, Lord, these orders have been passed, which are reflecting that the state owns up its mistake. And after owning up its mistake, then the court said, Mr. Advocate General, now you intercede, use your good offices to see what can be done. Whether it is 6, whether it is 2, whether it is 0, or whether it is 16, is now to be deliberated upon. So lordships may not keep it at 6 only. That's the problem.
That area is not to be mentioned.
So just area taku ye kar diyantu or dekhantu whether the amicable settlement between the parties is possible or not. Any land, vacant land, which can be
as proposed, sir.
as proposed, can be given to the petitioner for the purpose of money. So
23rd September, your lordship said?
23rd September.
2 p.m.
And Lord, I'm so sorry.
Maybe break.
Because there is
break benches.
2 parts it is. So one part is criminal.
The list is for first half and second half. So we can't take it.
So lord's missing it first half?
First half.
It has to be in first half.
10:30.
10:30. Grateful, sir.
10:30. Grateful. Lord, could your lordships just by a line, Lords, indicate that the learned Advocate General would be at liberty to call the parties or whoever wants to attend to get a grip of it.
How can you sit together?
But the opposite parties are not agreeing.
Obviously, you are to be intimated, Mr. Sharma.
Otherwise, it will be a closed door, one-way session, one-way house. The solution has to be bipartite. That's
Already
the
order that the AG said to see that. So definitely some communication is to be made to you or for this date fixed for this settlement talks, etc. We'll see that on the next.
Grateful.
yes, very well.
May I get a copy of that?
Copy of free copy of yours.
Grateful, obliged.
Item 2.
That matter, my learned friend has come.
Stated
fact,
that I was handed
next
over the file
Wednesday.
yesterday night, so I'm not ready. I said that Mr. Das will take advantage of your unpreparedness.
No, that I won't allow.
He said I will not allow it. So we'll take up this matter on
Next Wednesday, 21st.
So what is said that I have come. I am here.
No. So it is on 20th or
21st. 21st.
Please see that.
Next Wednesday.
Just let him see that. Okay. The Mr. Ajodhya Ranjan Das, National Government Advocate, submits that he has been handed over. He has been interested in this matter, and he takes some more time for preparation, and the matter may be taken Mr. Soji Sundar Das and senior advocate has no serious objection to such submission on consensus of both the parties. This matter on 21st August 2024. Matter will be taken up at 10:30.
Interim order.
Yes.
Noblest.
He has to pay. In fact, it is fees to people.
That is outside the court.
He has to pay, not outside, inside the court.
In terms of kind.
Milord, may I have to take a lordship's to mention, my lord, that matter which is arguing last week, lordship directed to be listed to come on Monday, my lord. In that case, where, my lord, the bank, without having any right over the property, my lord, has put an order of attachment. Your lordship wanted a query from me.
The counsel for the other side perhaps is not present.
Notice was not been released. Come for the first time. No, what has happened after this matter was taken up that day? The bank had sent some people with the police personnel. Actually, because the flat number was wrong, so they could not attach. That they have, after the matter was taken up, information has reached them, malad. Then they have become very smart.
So what we could perceive from the argument that you had the other day,
yes,
they have taken the agreement itself to be a document.
Yes, exactly, malad. And on the basis of agreement, how can
without having a specific performance of the contract or any document of sale deed,
nothing
getting attached to it, the property, which is the that is the terms of agreement.
Yes. Take up this matter on Monday itself. Tuesday.
The only thing is that if they come and after getting the information, they come with the police personnel also. That is the whole
Nothing
problem.
is coming on by way of an affidavit, Mr. Das. So just if something has been done, we should bring it on record by way of an affidavit.
Yes.
If you want any interim orders. So otherwise,
I'll make it. Can it be on Monday, Malad?
Monday is a holiday.
Tuesday.
That is how we are taking.
Quite right.
If you can come on Monday, there is no problem.
My lord's fellow residents to have some sumptuous food, Malad.
Yes. Item 62, subject on the last and senior is present. This matter on 20th of August 2020.
20th.
Okay.
A little bit higher up in the list, otherwise.
No, just make a mention in the first hour so that you can take. Because some phrase admission.
No, we'll do that.
Weekly list item number 28.
May I pray to call this matter next week, madam? Mr. Sadaki, senior counsel, will argue.
This is what we are told that this matter notice has not been issued. So you also verified yesterday the submission was made on behalf of the land council for this case. And so if notice has not been issued, then why it is coming here in this final disposal list? It should come in the heading of phrase admission. This matter was first taken off on 22/2/2023, then 5/8/2024, 31/7, then 5/8/24. That is the last time it was taken. And last time when the State Council submitted that he has not received a copy of the writ petition, we asked you to furnish a copy. Now perhaps you have already supplied that copy to you. So let it come under the head of admission next week. Okay. So this matter is coming under the heading of admission, which is meant for obviously final disposal. But it seems that the matter, no notice has been issued. So place this matter next week under the heading of fresh admission. Okay.
Item 29.
29. I am for the opposite party 6 and 7. I pray 2 weeks time for filing a counter. I have already taken time.
6 and
6, 7 and 8. NTPC.
7 and 8.
Yes.
But notice says that counter affidavit has already been filed by OP number 7.
No, I am for the NTPC.
आपको कितने नंबर कौन हुआ?
I am for the 1 to 3. 1 to 3.
Let us see 1 to 3. Who are 1 to 3?
One is NTPC, Chief General Manager, General Manager. So you have to take it till
1 to 5.
1 to 5.
1 to 5. Not also.
Okay.
Milits, I have something to point out to your lordships here, Milits.
Yeah.
This matter
also I have taken time. I have already prepared the draft counter and sent it for finalization.
Okay.
Well, may I just point out, I'm a little prejudiced at that point. May I just point out one thing to your lordship? Your lordships, by way of your lordship's second order on 14th of December 22 had issued notice. My learned senior had entered appearance on that date. 25/7, your lordships may see the fourth order. 25/7/23. Parawise reply was received by them. Fourth order, madam. Order number 4, which is dated 25/7/23.
So yes, he is right. How many times?
Yes,
you said in 23
I have
that you have received the parawise comment. Now 1 year has already passed and you are not able to prepare your counter affidavit.
The same.
Then you deposit 1 lakh rupees in the Advocates Welfare Fund in the High Court.
Only one.
Association.
Grant
You are
me one
NTPC, you can deposit
only
let
one
that money
time.
be utilized for the Advocate Welfare Fund.
Your lordship may grant me only 1 week time.
No, subject lakh in the Advocate Welfare.
No.
Otherwise, you will not allow.
Your lordship may just visualize, my lord.
Take down.
No, my lord, your lordship may.
No, sorry. It is. This is. You are taking 1 year time. Even in that order, it is mentioned that parawise comment has already been received.
Well, it's 19th of April. Your lordship may see one more order.
The same. Because my lord, the state has filed the counter.
Okay.
But they have not sought the copy.
All right.
The standard
they are mentioning everything. You challenge our order.
Challenging, not challenging.
No, it's all like this. No, you deposit 1 lakh.
Take it next week, Canada will finalize the matter.
Deposit.
Even if
let that money come from.
You will finalize the matter.
Why not?
Even without filing the counter, you can finalize the matter. We'll take it on record that you are settling it. If you are settling it, then we will take it on record.
Why this time is taken more? Because of they have challenged this matter issue is taken from the 1996 onwards.
They should suffer.
I'm not saying that he suffered.
Before how many division bench you have taken time? The court is not sitting here to grant you time and record just on your prayer. It is getting adjourned to one after another date.
3 times.
That's not there.
3 times I have taken. I have already mentioned before you.
7 times they have taken.
State has taken
1 year, 9 months.
I have also taken 3 times.
Don't try to compare with state. You have a different one.
I am not comparing with the state.
Because state has taken 3 times, you will be taken 7 times. Why?
That is not the
state has filed its counter.
State has filed this counter. I only take your lordship may take it next Tuesday. By that date, we will.
A mention is made on behalf of the Land Council appearing for opposite party number 1 to 5, seeking for adjournment to file the counter affidavit. Land Council for the petitioner has a serious objection to such prayer, and he pointed out the order dated Which order you are placing?
25/7/23, Malaj, which is order number 4.
25/7/20.
Aja. 25/7/2023. In which it is mentioned that the Learning Counsel for the opposite party number 1 to 5 made a submission that he had received the parawise comments and wants to file the reply. And on such submission, the case was adjourned after 2 weeks with for filing the reply. The matter was then listed on 27/3/2024. Again, the Learning Counsel for the opposite party number 1 to 5 took time to file the counter affidavit. Same thing repeated on 19/4/2024, 7/5/2024. Now, this opposite party number 1 to 5 again seeking for adjournment to file. It is strange that when a submission has been made a year back, that parawise comment has already been received and time was sought for to file the counter affidavit. The opposite parties number 1 to 5 are not filing the counter affidavit. When we were proposing to ask the opposite party number 1 to 5 to deposit a sum of rupees 1 lakh in the Advocates Welfare Fund, Orissa High Court, for granting adjournment till next week for filing the counter affidavit. The Land Counsel for the opposite party number 1 to 5 submitted that last chance may be given till next week, and you will ensure the filing of the counter affidavit. As a last chance, matter is adjourned to 20th August 2024. It is made clear that no further adjournment shall be granted to the opposite party number 1 to 5 for filing the counter affidavit, and the matter will be heard on merits. Yes.
I'm grateful. The Lordships are fixing it to 20th of August.
20th.
I'm grateful.
Item 30. Item 30, Your Lordship, it's a land acquisition matter for the petitioners, Your Lordship. In this case, the land belonged to one Natovar Behewat. He was the grandfather of petitioner number 1 to 3 and the father-in-law of petitioner number 4. So after his death, his land was amicably distributed between his 3 sons.
What is the stand taken by the state in the counter affidavit?
Your Lordship, the state.
It was to file the rejoinder affidavit.
Yes, we have filed. We have filed a rejoinder. But on the last date, the state asked for time to file a reply to that rejoinder, which we haven't received till date, Your Lordship.
Yes, any reply was filed?
No reply has been filed.
Filed? Why have you not reply?
No, not filed. We'll file a reply. Letter has been issued, we have not got any response.
But Your Lordship, this is the notification for land acquisition came out in 2007. And till date, they are saying that the land is pending for Bujarat. Bujarat, basically, if as per the law lexicon, Bujarat is basically a stage of survey and settlement operation.
That is not listed. Now, they must have proceeded for the next survey.
Your Lordship, they have even paid compared to other landholders, Your Lordship. If Your Lordship comes to.
No, when your land was acquired?
It was.
Come to your expedition government. How much land when it was acquired? Have you prepared a date chart?
Your Lordship, no, right now we do not have a list of dates. If Your Lordship permits, we'll do it on that.
Yes, one page note would be sufficient that this is the date on which your land was acquired. This is the land, and because it's been taken mentioned So, in
Notification was made
We
on
have
6th
a,
January 2007.
but Lordship, we have a, no,
Notification was made on 6th January 2007.
2007, Your Lordship. Actually, Your Lordship, I do in, as a matter of fact, I have a list of dates, Your Lordship.
so, how much land was been acquired?
Actually,
1.5.
13.10 acres of land was sought to be acquired, and of,
No, that is in total.
No, that is
and of
total.
that, 2.50 acres of land belonged to Notobar Beura, which was acquired. But
Who is this Notobar?
Notobar Beura is the grandfather of petitioner number 1 to 3 and the father-in-law of petitioner number 4.
Okay.
And when we were called in 2019 for the notice is given here, attached here, Your Lordship.
No, just one. Let us go step by step. Since
Your Lordship.
this counter affidavit has already been filed, so are they disputing that they have not acquired these 2 acres and 50 decimal of land of your grandfather or whatever it may be?
They have disputed the status of the land,
Ah.
which has already been settled by means of a judicial order, Your Lordship, and we have stated that in our rejoinder, Your
So have they
Lordship.
paid anything or not at all?
They have acquired my lands, and even my land has also featured on the list.
No,
of
the compensation
lands.
must have been determined, no?
They have, in fact, paid compensation, but not to me. They have paid compensation to other landholders, but not to me. There is a.
No, but what is the quantum of determination? How much they have determined, which you are disputing? Your dispute is with regard to the status of the land.
No, our dispute is that our land has been, no, not the quantum, that has not been paid a single pie of the compensation at all.
Compensation has not been paid to
No,
you.
not at all, Your Lordship.
Government can say.
In page number 18, Your Lordship.
Two counter affidavit. In the counter affidavit, what they have stated?
In the counter affidavit, Your Lordship, if Your Lordship comes to page number 37 of the writ petition, paragraph 8, they have actually admitted that the land in question by the petitioner is involved in the schedule of land produced by requisitioning authority for land acquisition, and we have attached that list of lands in our rejoinder, where it categorically shows that our land has been.
We are asking you something, you are answering something. In your paragraph number 4, let us come to your repetition. Paragraph
Yes,
number 4. Page number 4, paragraph 4.
Yes,
You have stated that Mr. Notobar Beura had 2 acres and 50 decimal of land.
Yes.
And after death, so and so was amicably distributed, so and so. Then by this notification, they intended to acquire the land, and then it did.
You got a reply through RTI.
RTI, yes. Then petitioners come to know that paragraph number 10, that all the landowners within the so and so had the acquisition happening have been paid the share of the compensation, save the petitioner only on the plea of non-production of a recent land record of the petitioner. Now, let us see what stand they have taken in the counter affidavit. Come to paragraph number 6.
Also, we can come to paragraph 11 so that not we can see it.
Paragraph number.
Petitioner beg to state that they are the legal heirs of the deceased and there is no dispute regarding the same. Hence, it is not reasonably expected for a person, especially an assuming village resident, to be aware of legal intricacies to safeguard himself. What is all this?
No, right. You come to paragraph number 6.
Yes, Your Lord.
Of that counter affidavit which has been filed by opposite party number 2 and 3. Mr. Kotkia.
Yes, Your Lord.
हाँ ते कौशंती ଆପଣଙ୍କର ଯେ village so and so is final village
final village and settlement operation was
not final village and settlement operation.
was in respect of the land in question stands as Anavadi status
and as classified
and Salo Jungle.
But if Your Lordship,
and that is quite clear in paragraph 11.
Paragraph 11.
Paragraph 11, 12.
It is on the petitioner was issued notice to produce documents regarding so and so. Date was fixed. Petitioner accordingly submitted the documents available with him in support of his claim. It is submitted on verification of the documents and order of the sworn. So it is found that the land of the petitioner in question is government land classified as sworn. So and
Tahsildar
Dangati. After the settlement operation, it is not possible to accept rent from the petitioner. Tahsildar had no jurisdiction to change the RO.
Then paragraph 12, that in reply to the government's mentioned paragraph 10 of the petition, it is already submitted that acre 13.10 decimal total land of Mauza, Boros Furidi, is now at Bujal stage. Since no hour has been passed, the payment of compensation doesn't arise. As regards one claim of petitioner is false and fabricated.
So number one, it is recorded as
Salo Jungle
and he is having no rent receipt also. That was also not produced.
But if your lordship permits,
claim, we'll hear you.
Yes,
Yes, and the claim is not entertainable. So, okay, that you have in support of that you have annexed that ROR, which shows that particular Salo Jungle.
No. It is CT1 land. It used to be a Salo Jungle in 1928-29. Thereafter, it was explained by the state. In a OLR proceeding, it was settled in favor of the petitioner as a wasteland. And thereafter, record of rights have been issued in favor of the petitioner in CT1 status.
Just show the averment state date.
Annexure 3.
Paragraph 4 ballots of the rejoinder at page 51. Page 51, paragraph 4. May I place that?
Rejoinder,
page 51, Your Lordship. Of the brief, running page 51.
51.
Yes. That to understand the entire matrix of the case, it's pertinent to point out that the land appertains to Khata number 52 of Mauja Swanso, measuring Swanso, which was settled in the name of Mr. Notabar Deuri under OLR case number 63 of 73-74. Mr. Notabar Deuri was possessing the said land as owner thereof in his lifetime and was paying rent to the government. That as Notabar Deuri was possessing the land as its owner and was paying rent to the government, he used to receive rent receipts in return. Mr. Notabar Deuri was the exclusive owner in the aforesaid suit land, though the system of the land was jungle prior to Sabiq settlement 28-29, but due to efflux of time, the nature and character of the suit land has been completely changed, and it was converted to wasteland during 1960 as per the then law, and the said land was reserved for various purposes. That Mr. Notabar Deuri was in possession of the said land, and it was duly and lawfully settled in the name of Notabar Deuri as Titivan status under this so and so before the Tahsildar Sukindar. This settlement was duly approved by the SDO Jajpur as well. Also, a working khatian was issued to Mr. Notabar Deuri, and he has been paying rent regularly to the state for the said land.
If that is so, then why didn't you produce the ROR and the rent receipts? They asked you to produce that.
My lord, ROR has been produced legally.
No. Here, what is annexure 3 in page 15?
Yes.
What is that? To read petition.
No.
Page 13.
Page 13. Page 30 is the record of rights. So the khatian, not final record of rights.
That is not final record of rights.
No. These are the Bhuja stage, not final stage.
Not final stage, yes. That is OLR Miske 63 of.
And the state acknowledges this. Kindly see the document at which I have annexed to my rejoinder. Where they have identified the names of the persons from whose lands have been taken.
Mr. Mukherjee, Counter affidavit.
Yes.
Paragraph number 11. Internal page is 4 and running page is 38.
38. Just a minute.
That Mr. Katkia was placing that paragraph.
Yes. Internal page 38, para 12.
Para 11.
Para 11.
Subparam.
Petitioner submitted documents available with them in support of his claim. That is the last sentence. That in
reply to the averments made in paragraph 9 of
9, it is humbly submitted that the petitioner was issued notice to produce the documents dated 31/4/16 by fixing the date of hearing to 30/4/16, and accordingly petitioner has submitted documents available with him in support of his claim. It is humbly submitted that on verification of the documents and order of Tehsildar Tanagudi, while miscase number so and so, it is found that the land of the petitioner in question is government land and classified as Sahoo Hon'Ble, and the Tehsildar has submitted that as the village is under settlement operation, it is not possible to accept rent from the petitioner. Tehsildar has no jurisdiction to change any ROR. Now that is the reason why Notabar Dehuri came up before this honorable court in a writ petition. Now that writ petition.
No, we just want to know that if these RORs, etc., were available with you and the rent receipt.
Yes.
When the notice was issued to you to produce those documents, why didn't you produce?
I did produce. I have produced. I have produced my documents. I have produced my legal certificates.
The government just you now read it.
Yes, it is meant.
No, it's all right. What you said in your rejoinder?
Rejoinder have said that I have appeared, I have given everything. Kindly see that government.
Please show that. What is your paragraph 11?
Yes, I am submitting.
No, probably reply is only to 14.
No. I have said somewhere that they have themselves contradicted.
Yes, that is what para 14.
Para 14. Yes. Para 14. Para 14, yes, indirectly it has been answered that it's hereby stated the claim of the state is contradictory and bad in law as if the land was under the ownership of the state. Then there seems to be no plausible reason for the person to go on paying rents to the concerned authorities and get rent receipts in return. This act of payment of rent in itself shows that Notabar Dehuri ownership over was undisputed and unhindered till the acquisition notification came out. Furthermore, the land schedule published by the land acquisition officer Kanagar so-and-so would not have had the names of Mr. Notabar Dehuri and the legal heirs of Mr. Notabar Dehuri in it if he were not the owner of the land in question. The enlistment of their names alongside their respective land is a concrete proof of the fact that the disputed land was owned by the petitioner and not by the state. Kindly see that document now. That document is at annexure 9 at page 59. This is the land which the state government, this is the state government's document, the lands which they propose to acquire. That document begins at page 59. Kindly take page 62. Yes. Page 62, serial number 56, 57, 58, 59, 60. Notabar Deuri and his sons. Even at the stage where they proposed to acquire, they knew who the land was. And my father's name is there, Vasanta Rai. So this bogey of Saro Jungle now being put forth is just to cover up their own lapses.
So, yes, Mr. Katkia.
Plus, yes, in the rejoinder, substantial improvements have been made, for which was probably the London Council was
That
appearing.
is exactly why that some new stand has been taken, not modification, but so that is why time was sought for and time was also granted to file the reply.
Yes, some more time is granted.
Reply is also necessary for because he has rightly pointed out that it is your document. In your document, you have accepted as if that these are the owners of the that. So now you are going back from what you have stated in that document. So, all right, we are granting adjournment till from first of we list it on the first of 2nd September 2024. Whatever you want to do.
And more plus 9 September.
The land council for the state seeks some more time to file the reply to the rejoinder affidavit on the ground that some new fact have been stated in the rejoinder affidavit for which a reply is very much necessary. The Land Council for the petitioner, Senior Advocate Mr. Mukherjee, opposed to the same. Be that as it may, place this matter and we commencing from 9 September 2024. Reply to the rejoinder affidavit be filed, if any, be filed in the meantime. Yes, next.
Item
31, Mr. Padi. Okay. What is this matter? Trilochan Das is the Land Council for the petitioner. And direct the opposite party number 2 to pay gratuity amount of rupees so and so. So, it's the order of the cat he has come, right?
But
4/8/2023. That is Annexure 1.
But your lordship, kindly have a glance to the order 31st January 2024. There is a dispute. 31st January 2024.
Yes.
There is a dispute that who will appear on behalf of AIMS Mirror. In behalf of the circular issued by the Health Government of India and Family Welfare Department, where the Union of India along with AIMS is a party, who will Central Government Council will defend the AIMS Mirror. So that is why this Honorable Court directed to sort out the problems between ourselves. And in the meanwhile, petitioner has served all the copies to the earlier council. Rejoinder, writ application, he has not served copy to Osmer. But in fact, in view of this circular, we will defend the case in this case. We have already filed the circular earlier also.
So AIMS was represented by separate lawyer.
Earlier.
So you now Union of India will represent.
Now in view of the Health Department circular, we will defend the AIMS.
I think Aurobindo Mohanty was there at that point of time.
Yes.
For the AIMS.
For the AIMS, but lordship, kindly see, I have elected circular of Health Ministry.
They are both Union of India and so on and so are party government both ancient.
After that,
he has not written you this, Mr.
No, he has not written. Not. So the petitioner may be directed to
Petitioner Nahandi Tosiya.
next
You
speaker.
have got the phone number of Mr. Das.
I'll collect my. I'll collect.
That number nowadays is there in B-Nama, so we can take that.
My
Non-obvious petitioner, the Learning Council for the Union of India, representing Government Council, Mr. Produce the dated 2/5/2020, issued by the Government of India, Ministry of Health and Family Welfare, wherein it is mentioned that where both Union of India and AIMS are, the Government Council will represent both AIMS and Union of India, and no private council to be hired by AIMS. Accordingly, this memo is letter is taken on record.
These are earlier circulars, relying on this circular,
Some circulars were filed. The memo is also taken on record. Land Council, Central Government Council submits that the writ petition copy and the counter affidavit. How to come earlier?
Rejoinder, everything I'll collect.
All been served on Mr. Aurobindo Mohanty when council was appearing for AIMS, and therefore the land council for the petitioner may be asked to supply the same to him. Let the land council for the petitioner give a copy of the petition from counter affidavit you have.
Yes, I'll collect. Yes, I'll.
That's counter affidavit again. Rejoinder affidavit filed by rejoinder affidavit to the counter filed by opposite party number 1, 2, 3. To Mr. Gupta by next week, matter to be listed 2 weeks after now.
Yes.
And to delete that name, the name of Mr. Aurobindo Mohanty shall not be indicated in the cause list, and the name of Mr. P.R. Gupta, Central Government Council, shall be reflected along with Mr. Prashanna Kumar Padi and Deputy Solicitor General.
Item 32.
On behalf of the petitioner,
They have challenged possession notice.
I am for the petition related to one capital malady case.
I need someone not to believe. The petitioner has challenged this also.
Here the petitioner is the guarantor malady, Lodni committed suit.
For the Supreme Court, alternate remedies available. Court of challenge
Annexure 6, page 18 below.
6, page 18 is challenge to Nasankar presence note for level, that is on behalf of the Urban Cooperative Bank in Rapport. Yes.
Obliged.
Item 33.
Pass. शुक्रवार फ्राइडे
Judicial officer.
ଆଜ୍ଞା ପ୍ରୋଗ୍ରାମରୁ ଆନାଲିଷ୍ଟ ହେବା କଥା ଗ୍ରେଡେସନଟା ଚେଞ୍ଜ ହେବା କଥା ସିଷ୍ଟମ ଆନାଲିଷ୍ଟ ହେବା କଥା ପ୍ରୋଗ୍ରାମର ଅଛି ସିଷ୍ଟମ ଆନାଲିଷ୍ଟ
He is not judicial officer, sir.
No,
He's an employee of High Court.
Employee of the High Court.
You're asking whether he's a judicial officer. You said. Yes. Counter has been already filed. The rejoinder also filed.
Everything. Notes of submission is
So, password you want?
Password. Friday ko rahila na aji Friday ko
Friday Indian bench is not there. So
password
you want can be taken up next week or it's
password Monday.
Monday is a holiday, so it is to be taken up on Tuesday.
Tuesday.
Okay. Mention is made on behalf of Mr. Pujari to adjourn the matter next week, which is on 20th of September 2020. Yes.
Item 34.
The petitioner seeks to challenge the order of the land, additional district magistrate directing for resumption of land in purported in excess of power under Orissa Government Land Settlement Act. For the land lease was granted under Government Grants Act, my lord. I file a note of submission, my lord. That's it.
We did come on Monday. Monday.
Okay. You've been handed over his stuff. Some citations also he has handed over to you.
Copy date. Along with copy.
Yes, boss. Yes.
I will do one.
The land counsel for the petitioner, Ms. Patnaik, handed over the note of submission, memo of citation, which is taken on record. Copy of the same has been served on the land council for the state and court today. It will take some time to go to the same and address the court next week. With this matter, we commencing from 20th of August 2020.
Item 35.
Petition for substitution, my lord. The petitioner, original petitioner has died on 24/6/24, my lord. I filed this petition.
That is within time. Any objection?
Wife is seeking substitution.
Not received for formal substitution.
Not a copy.
I have solved the copy, my lord.
Look on the IN number so an application for substitution of funds for the deceased petitioner. The wife of the petitioner has filed this petition. After going to the no serious objection to the this is the result is to fight the consolidated. So 1 week time is granted that consolidated declaration because it is the name of the yes. IA dispatcher.
In this case, I have already filed counter affidavit copies of.
Only one request to Lordship.
Yes.
Can it kindly be fixed for hearing? I am filing the this amended cost title on by next Monday, Tuesday.
We just said that amended cost title.
First, we fix it for hearing.
And the counter affidavit has been filed.
Filed copies of.
Copies of. You do not want to file any rejoinder.
I will not file this.
You do not also intend to file it. Otherwise, in the midst of the hearing, you will say that.
No, I will not file.
Oh. Then this will be in this list under the heading of admission. It will come on 27 and it will be finally disposed of. Okay. Yes.
Okay.
Item 36.
The petition is a retired junior field assistant under the ARC Charvatia. Well, retired in 2016, but not getting pension because of the fact that the old pension scheme is Central Civil Service Pension Scheme 72 is not applicable to you. So, my lord, my original application was rejected. The office memorandum, my lord, of the Government of India, which are helpful to me, and it is these are all clarificatory. After coming into force of the new pension system to effective from 2004, So the series of my office memorandum of the government of
1/1/2005.
My lord,
1/1/2005.
नहीं our state asla 5 central government 1/2004. So my lord, the series of office memorandum of the government of India have not been properly dealt with by the tribunal. As a result, I lost my case before the tribunal. So my initial appointment engagement in 1987. So by the interference of this honorable court, so we are my lord, services were restored back. So it was the in 16/8/2024 were issued the fresh appointment order. So in a regular post. So my lord, this the very annexure 8 page 55. It is very important, and everything will be my lordship will page 55 regarding applicability of the old pension scheme. Those who are engaged prior to the new pension system and regularized after 1/1/2004. Page 55. I am reading. It is my lord, issued by the Minister for Prevention and Pension Administration. My lord, the undersigned is directed to refer this office memorandum of EB number 26 February 2016 on the above subject and to say that some references have been received in this department from various ministries department seeking a clarification with regard to para 7 of referred office memorandum. The office memorandum was issued in consultation with the Department of Expenditure and the Department of Pension and by Lord the Public Welfare. It was clarified by the office memorandum that the department's office memorandum dated 26 April 2004 have been quashed in a series of orders judgment. The office memorandum dated 26 February 2016 restores the previous provisions of the scheme as it existed prior to office memorandum 26 April 2024. The benefit of GPF and old pension scheme is applicable to all those casual laborers who are covered under the scheme of the 10th September 93, even if they on or after 1/1/2004. As the benefits of the old pension scheme and GPF is admissible only to those casual workers who are covered under the scheme of 93. All ministries, departments may strictly ensure that does not lead to demand by regularly recruited fresh employees appointed after 1/1 for similar benefit in place of NPS. So, my lord, this circular, office memorandum, 28 July 2016, it is again clarified, my lord, the rejoinder, the rejoinder, annexure 16, the office memorandum 17/2/2020. Coverage of Central Civil Service Pension Scheme 72 in place of National Pension System of those central government employees whose selection for appointment was finalized before 1/1/2004 but who joined government service after 1/1/2004. So it is also helpful to me. Circular Annexure 17 on 3/3/2023. My lord, the coverage of the coverage under Central Civil Service Pensions rules in place of NPS. Paragraph 3. Paragraph 3, my lord, reading. Representations have been received in this department from the government servant appointed on after 1/1/2004, requesting for extending the benefit of the pension scheme under Central Civil Service Pension Rule 1972. Now 2021 on the ground that their appointment was made against the posts, vacancies advertised for recruitment prior to notification of the National Pension System, referring to the court's judgment of various Honorable High Court and Honorable Central Administrative Tribunals, allowing such benefit to applicants. Next para. The matter has been examined in consultation with the Department of Financial Services, Department of Personnel Training, Department of Expenditure and Department of Legal Affairs in the light of the various representations, references and decisions of the court. In this regard, it has now been decided that in all cases where central government civils employed against a post or vacancies which was advertised, notified for recruitment, appointment prior to the date of notification of the National Pension System 22 to 12 2003 and is covered under the National Pension System on joining service after 1/1/2004 may be given a one-time option to be covered under the Central Civil Service Pension Rule 72. The option may be exercised by the concerned government or latest by 31st August 2023. So, my lord, by virtue of this office memorandum and which are beneficial to the, my lord, the old employees, those who were engaged prior to 2001-2004 and consequently they were regularized after 1/1/2004 or appointed by the court order or by accepting the representations. So they will be covered under the old pension system. So my engagement under the establishment 87. So when we are retrenched by the management, the honorable court and by the interference of the honorable court in OJC, so our services were restored back. So in time it was also not carried out. We filed the contempt. So in contempt, when the stringent action was yet to be taken against management, so they offered the appointment in 2004, my lord, 16/8/2004. So, my lord, now they are saying on the accepting the representation, it was, my lord, the clarification.
This court.
Yes. But tribunal's order. Annexure 15 page.
It was passed and.
My lord? Yes. My lord.
We're just coming within 2.
My lord. My lord. The order of this Honorable Court, my lord, page 43. Page 43. But on the order portion, my lord. So the counter, we have seen that there is no averment by the opposite party note 3 and 4 that the applications of the petitioners have been considered with due weightage with regard to their experiences, though their suitability for the post has been considered and persons who are qualified in view of the academic qualifications have been considered for the post of aircraft assistant. But while considering the academic qualification of persons who have not been found suitable, no weightage was given for their experience. There is no averment that due weightage was given for the experience and the persons who have otherwise found suitable. Therefore, the tribunal is not correct in committing to the conclusion that the opposite parties have taken adequate steps to implement the order dated 15/11/93 passed in way 30/92. It may be kept in mind that persons who have rendered long period of service in a particular post, such post can be regarded as a necessary for the organization. In view of the aforesaid discussions, we direct the opposite party number 3 and 4 to consider the applications of the petitioners if they are found suitable with due weightage to experience while making selection against any of them on casual laborers in organization. So, my lord, this judgment was delivered by the Honorable Court on 21st November 2000. So, my lord, after my lord, this judgment, so they did not implement it. So, we filed the contempt. So, in contempt, so they are considered the management under my obligation. So, carried out the order. Thereafter, Annexure 14 in 2004, I was given engagement. 16/8/2004. So, after rendering service for some year, I approached the authorities to regularize my period of absence. So, they have accepted, my lord. So, in the acceptance letter, page 61, I am not praying for any service benefit for the period. We sit idle. Page 61, my lord. After my son, A. Well, at the time of admission of this my writ petition, it is observed by the Honorable Court, page 61, that the applicants in the said way being disengaged from 35/94 to 2004 were no longer in service. Therefore, unless the intergame period is regularized, the applicant's date of regular appointment by no stretch of imagination could be antedated. So, for the period, my lord, I was not in engagement. See, period 94 to 2000 because of the litigation.
No, that was the contention.
Yes. Yeah, my lord. So, my lord, this contention is clarified, my lord. मैं चाहूँ my lord, ये जो intergame period था.
No, you said that you have been regularized. What is that? That period, that particular period of your disengagement has been regularized. So where is that?
Yes, my lord. They have not regularized.
Then? No. You said that it is regularized.
My lord. Yes, my lord. After our appointment in the regular establishment, 2004, जोड़े 16/8/2004 16/8/2004 पूर्व सर्विस टा आमे चाहूछु if it would be counted जोटा कि ऑफिस पेरोल सर्कुलर कहले 2016 ले if the past service would be counted, then you will be covered under the old pension scheme.
And no doubt about it.
Yes, my lord.
Obviously.
My lord, yes, my lord. Yes.
But whether it is counted or not, it is your case.
My lord, age of rule 27 ta effect of interruption in service. An interruption in service of a government servant entails forfeiture of past service except following cases. 2, notwithstanding anything contained in sub-rule 1, the appointee may, by order, commute retrospectively the period of absence without leave as external leave. So, I pray, they are without any service benefit, the period of my past service rendered.
This court, when you approached this court earlier, which you are just placed in Annexure 4, there was just a direction to dispose of the consider the application. No direction was issued from. So your application must have been considered as per the because you filed thereafter the contempt petition. So what final order was filed by the authority?
We are taken back to the regular establishment.
No, that's all right. That's right.
But the intervening period.
That intervening period, that is the crux of the issue.
Yes, हाँ से जो intervening period टा सेटा representation देलु after coming into force of the जो office memorandum 2016, 2020, 2023 that the intervening period be regularized and we are not claiming any service benefit or arrear pay. But ସେଇଥିରେ on considering our grievance pilot, 3 of our co-colleagues same in putting similar engagement order, Samar Kumar Pal, Amul Kumar Pal, same जो मान थिलु हमें co-colleagues under the ARC, so they are getting pension under the old pension scheme. Samar, Amul and Rajanikanth. So we drew the attention of the authorities, these similar situated co-workers, they are in receipt of pension under the old pension scheme. And presently, my lord, another employee, Benudhar Oja, also, my lord, favored with an order directing এটা ବି honorable court officers dispose of କରିଛନ୍ତି with a direction to the respondent 1 to out the clarificatory circulars. WPC 13.
So you come to your prayer post, page number 14. In Roman 3, what you have stated.
My lords.
Your writ petition, page number 14, Roman 3.
Roman 3.
That the opposite parties
to
regularize his past casual service rendered from
7387 till 15/8/2004.
That period you are not working. You are a particular period 1987 ରୁ 2004 ପର୍ଯ୍ୟନ୍ତ ଆପଣ ଟୋଟାଲ ପିରିୟଡ ନଥିଲେ
ନଥିଲୁ ମାନେ 87 ରୁ 94 ଯାଏଁ ଥିଲୁ।
ହଁ
87 94 ଥିଲୁ 94 ରୁ 2004 ଏ 10 ବର୍ଷ ନଥିଲୁ। ସେଇଥିପାଇଁ ମାଇ ଲର୍ଡ ଯୋଉ ଆନେକ୍ସର 9 ରେ the management my lord the respondent they observe that unless the intervening period is regularized.
Yes, my lord.
Yes, my lord.
Regularized means the services rendered by you from 1994 till 2004 is only to be computed for the purpose of pensionary benefit. That is what you intend to say. That is not your prayer. It is not prayer.
Not the prayer, Mr. Counsel. That is not the prayer.
My lord, ସେଟା ଯଦି my lord with due respect ତିନି ଜଣଙ୍କର allow କରିଦେଇଛନ୍ତି।
ଠିକ ଅଛି କିନ୍ତୁ କାଇଁ where is that? ତିନି ଜଣଙ୍କର କାହାର କରାହେଲା କାଇଁ? Which document?
ପଛର ପାଇଲି ସମର ଅମୁଲ and other.
No, it is with you or you have filed it? Keep it in your file. What you will do?
ଏବେ ସବୁ ପଛରେ collection just 2 days back.
So you
2 days back.
In the copy.
ଆଜ୍ଞା ଦଉଛି my lord.
How you will examine that?
Yes, my lord.
Similarly situated.
With due respect ମୁଁ ଦେଇ ଦଉଛି affidavit କରି ଦେଇ ଦଉଛି।
Yes.
At page 8, annexure 15, page 80 of the impugned order.
Yes.
Para 6 months.
Yes.
Admitted fact of the matter is that the applicant was engaged as casual laborer on 17/3/1987 and worked till his disengagement on 13/5/1994. He was engaged under a scheme, and after closure of the scheme, he has been disengaged with effect from 13/5/1994. It is admitted that the applicant was engaged for till 30/5/1991, and thereafter for 17 days in a month till 13/5/1994. He didn't have engagement for 240 days.
That means it is not a continuous period.
Yes, ma'am. And it is also admitted the applicant was appointed on 18/8/2004 and retired on 29/2/2016, madam.
But he was saying that he was continuing.
I am coming to that point. And here, my lord, one thing arises. He retired from his service, government service, from regular establishment, with effect from 29/2/2016, madam.
Yes.
But since long back, 18 years back, madam. Firstly, this
2016 ଟା ହେଲା 18 ବର୍ଷ ତଳେ।
8 years.
Yes.
8 years, madam.
Yes.
So, he has filed the OA, my lord, which has been disposed of with effect from 2023, my lord. 6/9/23. Firstly, it was barred by limitation. After his retirement, he is claiming for regularization of his casual period. First leg of secondly, my lord, kindly have glance for us. It is the case of the applicant that if he is granted temporary status, and I will pause for a moment here. But what is the rule? But when a casual employee got engagement under as casual laborer, first he has to grant temporary status. Thereafter, he will claim for regularization. But in the previous OH, which have been filed before the tribunal, he has never raised for temporary status. So he only prayed for regularization of his service, and that has been declined by the learned tribunal. Thereafter, it is seen the applicant was engaged from 17/3/1987 till 13/5/1994, but he never agitated for grant of temporary status before the respondent. He also never approached any court or tribunal praying for the same. Even though he has filed cases before the tribunal or Honorable High Court, the prayer was for regularization. Therefore, at this distant time, after his retirement, prayer for grant of temporary status is barred by limitation. Thereafter, my lord, kindly have a glance to paragraph 9, my lord, of the impugna. The applicant had also earlier approached this tribunal by filing OA number 177 by 2010, which my learned senior is suppressing that fact, praying for a direction to the respondents to quote their past casual service to counter their past casual service which they had rendered in the project. This tribunal, by the order dated 21/8/2012, had dismissed the OA in a batch of cases for conservation matter. This fact has been suppressed by my learned. The earlier OA was disposed of on 21/8/2012. And what are the observation matter? Next page 82 subpara. The project in which the applicant was continuing on casual service was closed in the year 1994. Thereafter, they have approached this tribunal in OA number 30 of 1992, 349 of 1995, seeking regularization of their service. However, being agreed by the order passed by this tribunal, the applicant approached before this Honorable Court, High Court of Orissa, number 1494 of 1999, in compliance to the order of the Honorable High Court of Orissa dated 22/11/2000, the cases of the applicants were considered and all of them were appointed against temporary posts by the order dated 16/8/2004. The undisputed fact of the matter is that after the closure of the project, the applicants were not even in casual engagement. Hence, we find that the prayer of the applicant is baseless, being not supported with any authority. Hence, all stand dismissed, being devoid of merit.
Yes.
But here, earlier OA has already been dismissed, and that was, it is pertinent to mention here that matter. They have not even challenged that order before this honorable. So that order stands as it is. This proceeding has been filed after that manner. So it is hit by res judicata also. Thereafter manner, what is the observation of the learned tribunal? Para 10 manner. In the above order, this tribunal has not been challenged by the applicant and has attended finality. It is also seen from the orders of the Honorable High Court in both the OJC and CP that no observation was made for regularization of the applicant, but for appointment. And accordingly, the respondents gave them appointments in the year 2004. I am pausing for a moment. So, by virtue of this Honorable Court's direction in CP, these applicants got appointment. But this Honorable Court never regularized their service. So, the appointment got in the year 2004, it is a fresh appointment in regular establishment.
No, it's all right. We follow you. Just he said that similarly situated persons have been granted to please examine. If his case is covered, matter is all right. Otherwise, we'll hear.
Yes.
So let it come on Tuesday, and you go to the. How many judgments have been pronounced?
Well, my lord, three persons.
3%.
3%.
That is the judgment of this court, or
No, on the basis of the representations.
Oh,
Yes,
the authority have a
yes, one thing is that he is reading the order of the 2012, but the different associations of the world employees.
Okay.
So, ये जो 2016, 2018, 2019, 20, 23, ये जो series of office में आसिला, liberalizing. My thrust is liberalizing.
Prepare the written.
हमारे में सेटल कर दो, yes, कर दो, हाँ. Yes, my lord. After liberalization, I making a demands for lordship.
Those 3%. They were also engaged in that project.
Yes, my lord.
Casual labor.
Yes.
And they were also thereafter there was a discontinuance. Then again they were engaged temporarily after 2004.
So after 2004, मतलब সেই जो judgment ଆମ ଅନୁରୋଧ କୋର୍ଟ judgment 2010 जो 2000 OJC ରେ ତାରି ଫଳରେ ସମସ୍ତେ ଆମେ ଆସିଲୁ ମ୍ୟାନେଜମେଣ୍ଟ କୁ ଏବଂ ବର୍ତ୍ତମାନ ଯୋଉ ଏଇ 3 ଜଣ ପେନସନ ପାଉଛନ୍ତି ତେଣୁ yes ମ୍ୟାଡମ ତେଣୁ ଏଇ ଯୋଉ ମାଇନର ଏଇଟା ଗୋଟେ ମ୍ୟାଟର ଥିଲା ବି ଅଣ୍ଡର କନସିଡରେସନ ଅଫ ଦି ଓପି ନମ୍ବର 1 and 2
ତାଙ୍କ ନାଁ ସେ 3 ଜଣଙ୍କ ନାଁ
ସମର କୁମାର ପାଲ
ଜଷ୍ଟ a minute ସମର କୁମାର
ପାଲ ଅମୁଲ କୁମାର ପାଲ ଅମୁଲ କୁମାର ପାଲ
ଅମୁଲ କୁମାର ପାଲ yes
ରଜନୀକାନ୍ତ ପଟ୍ଟନାୟକ
ଏମାନଙ୍କ ଫେଭରରେ କେବେ ଅର୍ଡର ଟା ପାସ
ଏମାନେ କୋର୍ଟ
no the department has allowed them
department এই 2008 17 or 18 এই 2016 28 7 16 सर्कुलर পরে এই जोड़ा annexure 8 giving emphasis my lord 28 page 55 টা it is helpful to us ଆଜ୍ଞା ମୁଁ ସେଟା ସବୁ ଦେଇଥିବି ମାନେ the administrative order as well as pension
basing on that did you represent to the authority what happened
my lord
did you represent your case
my lord
at par showing your petitioners to be at par with
yes my lord yes
what happened to that
so because they are saying that your case is sub judice in the court of law
where is that
नहीं इंटिमेशन करी ना
सब आपण
नहीं आ जण को दे देछंदी
एटा देखैले आपण से जो
तीन जन
अच्छा ड्यूरिंग कोर्स ऑफ हियरिंग है ना the learned counsel for the petitioner Mr. Subhanshu Bhushan Mahanti, learned counsel for the petitioner, submitted that 3 similarly situated persons, namely Samar Kumar Pal, Amul Kumar Pal, and Rajanikant Patnaik have been granted the benefits by the
benefit of
pension by the authorities, and he will hand over the copies of the same order passed in favor of those 3 persons to the learned counsel.
Yes.
Appearing for the learned central government council, central government council. By କେବେ ଦେବେ
by Friday ଦେବି Friday at least Monday by Monday
acha by Monday it is further submitted that
Tuesday
all right by Tuesday it is further stated by the learned counsel for the petitioner that though a representation has been made to the authorities to consider his case at par with those 3 persons but no response has been received and it is kept pending since this case is pending before this court. That is his submission. So the learned counsel, central government council, shall also obtain instruction about the result of any representation filed by the petitioner. In the meantime, this matter, 27 तारीख this matter will be commenced from 27. In Tintan, ठीक से लिखी है ना So Bhavani Shankar Rai को ना देखिए है ना Central Government Council.
Item 38.
37 टा कौन है भाई? चलिए केबे रहिला?
May I please, Your Lordship? Your Lordship, this case is with respect to seizure of vehicle by the opposite party without any notice to the petitioner of this instant matter.
Waiting for the other side. Mr. Nalinikanta Das, D. Panda, S.K. Aziz.
My lord, I am on receipt, my lord, item number 38.
Yes. So, what is your prayer, Learned Council?
Your Lordship, my limited prayer is that we are willing to pay installments that is due on us if 7-day period is granted. However, the vehicle that was seized by the opposite party may be restored to us in the same condition as it was taken from us.
What was his condition?
It was in the working condition, Your Lordship.
Yes.
It was in the
running condition.
It was in the running condition.
Private finance company.
Yes, Your Lordship.
How
could you maintain?
Your Lordship, because they have violated a specific provision of the SurfAC Act.
SurfAC Act, you can go to the other forum. If it is a private organization, how it is maintainable? That is the exact question which you will.
Your Lordship, because the private organization has violated a right that is of the petitioner that has been specifically provided in the SurfAC Act. That is why, due to the violation of the right, we have filed a writ petition for this matter.
All those, that is SurfAC Act, all the banks, they are
amenable.
Different matter. It's a nationalized bank or something. Say, so they are coming within the definition of state. How do a private company will come within the scope of state so that this Article 226 direction can be issued?
I bow down in front of Your Lordship. My limited submission.
Whatever, once the REIT is not maintainable.
Yes, Your Lordship.
Because the private body against the private body, the state that is no petition is maintainable. You may file a civil suit; it's all right for getting your claim, whatever you are. But to exercise the REIT jurisdiction, the other side should be a state. That is the minimum thing.
You have filed the counter.
No, my lord.
This is Chola
Investment and Finance.
Private organization. You examine this, you can examine that term.
So, because the ambit of Article 226 is wider than the Article 32.
Your counsel, you just go through the citations of this court, of this Honorable Supreme Court, whether against a private body REIT will lie or not.
Yes, Your Lordship.
जहाँ mind prepare करी आसचंदी सेतिकी खाली कहिला हबनी.
Yes, Your
जहाँ
Lordship.
question put होची ताको मधे meet करिवा दरकार.
If you want to bring it with Article 12, bring the instrumentalities of the state, you have to bring. All right.
Yes, Your Lordship.
Then
If Your Lordship could give me few an adjournment, I will do my research.
You are ready to answer, but you are going on repeating the
No, so extremely, I'm so pardon me,
Land
Your Lordship.
Council for the petitioner seeks for an adjournment to apprise us how a REIT is maintainable against the opposite party number 1. Opposite party, opposite party. Yes, next.
My lord, in this case, you can. I have to file an objection. He has filed an amendment application. My lord, no. Yes, you have filed, my lord, because his prayer was Schedule B property रा
Yes, yes.
What fell from your lordship's mouth was Schedule B तो prayer answer है. Now you are claiming on Schedule A.
I am submitting.
So I have only one thing to say, my lord. Pursuant to your lordship's order in January 2024, the auction purchaser was made a party. My lord, he has filed a suit which is let's go to him also, my lord. I am saying addressing your lordship on that. आगे तुमका आपके January your lordship told that जेतले DRT settlement hela auction purchase is 25% नहीं he was a party there. 80 my lord directed him to make a party. Now schedule a property where जेतले से करूची notice has to go to him also. I will file my reply to this also, my lord. That is my limited submission.
I am petitioner in this case.
Then otherwise, tomorrow will come up with a lordship that I am a party, I have not received a copy of this miscase. It is directly affecting my rights.
I respectful submission petitioner in this case. My respectful submission is that I have filed a petitions for amendment of the prayer persons in 6 lines of one sentence consists of 9 words. Only for specifications.
Just a minute, Learned Council, when this matter was taken off on 6/8/2024, the order reads like this: that Learned Council appearing for the OP1 filed objection affidavit, which is taken on record. Copy has been sought on. During course of argument, Learned Council for the petitioner submits that he shall be necessary application for amendment of the prayer portion of the writ petition.
My lord.
And interim applications, if any, be filed in the meantime, shall be so answered.
Yes.
So thereafter, what you did?
I have filed the amendment petition, that is flag D, and consulted prayer person is flag E.
Yes. And you served a copy of this application?
Yes. My lord, I have received. My lord, kindly see. Initially, there were 3 opposite parties. My lordship.
Complete submissions.
My lord, a person who is being affected. Let us not fight. I am just uprising the honorable court.
What is?
Let me see the order dated 22/1/2024. What is the first order? First order, the 2 parts of the order was there. Second part, Schedule B property as per the prayer, we have handed over possession, documents, everything. That is not disputed also. So that person was filed to shoot Mala before the Baleshwar.
Time file an application to implead Subrat Kumar Pal, the auction purchaser, as a party to the proceeding. Yes.
At that time, the court felt that he is not a necessary and proper party, and my prayer is not against him.
Then, because it was Schedule B property.
Yes.
Schedule B property.
Yes.
But my submission that he is not a necessary party, and his presence is not required for allowing me any relief. His presence is not required. So the honorable court.
Correct. You come to your prayer portion. Let us see.
Yes.
Let us be clear on that.
No.
Prayer portion is at page 10 of the writ petition. Please come there.
After amendment, it will be.
No. It is amended.
Before amendment.
Before amendment, after amendment, it will be. Yes.
I mean, amendment.
Therefore, humbly pray that this honorable court graciously be pleased to allow this writ petition and to issue writ in the mandamus or any other appropriate writs directions directing the opposite party number 2. Opposite party number 2 is the branch manager authorized option of the to hand over the keys of dwelling house, which they have to dwelling house situated over the Schedule B land. Documents and thereafter 9 amendment in as per amendment, this will be documents of Schedule A and B property, closure of 3 accounts, and no due certificate of mortgage property, or may pass any other approved order. This one thing just.
That is your proposed amendment. My lord is asking prior to that.
आगुरु या थिला तो जो जहा पढुचंदी वर्तमान सेतिको भी पढिया को धर्जन आपण कुहाउची प्रेयर पोर्शन टा पढन अमेंडमेंट एपर्यंत आपन अलाउ हेनी आपण ताजरु मिसेई किन कहि दोचंदी
documents after documents no due certificate of mortgage property or may pass any other appropriate
Okay, the
direction.
submission which was made that the Schedule B properties, it has already been handed over, whether it is a correct statement or not.
They have handed over after observation of this honorable court.
Okay.
After observation of the
So
honorable
Schedule B properties now is in your possession, right?
My lord.
Okay. Now, if this amendment is allowed, as you prayed for this 10524 of 2024,
My lord.
what you want to amend and what would be?
For specification, I make prayer, nothing else. For specifications, the documents of Schedule A and B property, closure of 3 accounts, and this 9 words, consist of 9 words. This is amendment.
But once Schedule A property comes, if your lordship sees page 23, is not 23.
Of Schedule A and B property, closure of 3 accounts, and no due settlement.
Once Schedule A property, lordship sees page 30, where the essay जो final order pass ହେଲା, ତାଙ୍କର settlement ହେଇକିରି, where the Subrat Pal was a party. One. That is why your lordship took cognizance and told that you make him a party on his representation, my lord. That is the order I was pointing out. Now, Schedule A property, he is himself saying a suit is pending for right title and interest where we are both parties.
ଆପଣ Schedule A property କୁ amend କରିବେ ଯଦି ଆମେ that has to be it's all right, it is to be, but what he is stating, Schedule A property has already been handed over to the auction purchaser.
No, not to the auction purchaser. He has sold it.
No, nothing.
Auction purchaser has filed a suit, my lord. After this DRT order, where he was a party, where it was settled by taking the dues from him, my lord, he filed a civil suit, making the bank and him a party, saying right title interest diyajo Baleswar, which he has himself pleaded. So once Schedule A property amendment comes into play, my lord, at least notice to then tomorrow, my lord, if your lordship passes some effective order, he'll say, I have not been heard recall petition.
Harm to issue not due certificate. What is the harm to close the accounts to 3 years has already been? I am a businessman. I am not getting any loan from any bank because of non-close 3 accounts. Non-closure, non-issuance of for this reason, only this reason, the civil suit is pending. A civil suit is pending. In the civil suit, they have not relied this document. Only because they bank the party, third party.
You are a party in that civil suit.
Yes.
So let us see that what is the prayer made in that suit.
Made in the plate.
Yes.
We should. For the declaration of Schedule A, even if they have not relied the document, the party, the third party has not relied. I have cleared my loan dues. There is no a single pie pending outstanding against me. They are not issuing the non-due settlement. They are not closing.
No.
That's because I am not satisfied the illegal demand.
No. You have cleared the dues after the auction purchase or before that?
I paid the dues.
When did you complete the dues?
In the 2022, in the year 22.
The question that was put to you is whether after the
auction purchase
property was placed
put to auction
and the auction purchaser deposited the entire money.
No, 25.
No, what had happened?
25%, yes.
What had happened? He had deposited 25%. When he challenged in an essay,
right,
interim order was passed. Due to interim, then it stood like that, my lord. And then he deposited the entire amount in 22. During pendency of essay, he sold the Schedule A property. He has averred that also at paragraph 13. Auction purchaser, my lord, was made a party there. DRT felt that as we are going for settlement and he has deposited 25%, he was made a party at page 30, lordship will see. Thereafter, my lord, Schedule B property, Schedule A property, I kichi deluni veli came before your lordship.
No, lordship told they have returned the amount, 25% of the interest they have returned to the third party.
My lord, in counter affidavit, have given everything.
Return.
What happened, my lord? What happened? The auction purchaser, my lord, deposit 25%. He filed a civil suit, making us and him a party, claiming right title interest over the Schedule A property. So in that background, Schedule A B have a kitchen
property which was put to auction, and against which you had paid 20%, which you have refunded.
Yes, madam.
So
the suit is now
that you have already accepted this amount.
Yes.
On the basis of a direction.
No, no, that
is obvious. I have completed as per obvious. I have entire amount.
All right.
essay my lord, final
In 2022.
2022.
my lord, order.
Closing my accounts.
My lord, both
When you civil, my civil point is very good.
my lord, at this point,
Therefore, I am businessman. I am not getting
my
a
lord,
loan from any bank.
my lord, at this point, what is his objection in issuing notice to this amendment petition, where schedule law, your lordship is now going to adjudicate? Admittedly, a suit is there. I am not saying I will not file objection, but unless he appears or a notice issued, my lord, if some order is passed, my lord, on merits, then tomorrow he will come up before your lordship. He may come up. So to avoid I go to him, he has been made a party.
Kindly have a glance view of the Honorable Court on 2/11/24, 2/1/22.
There are two sets of orders.
Of the court, of the view of the court.
So that view has already been complied with.
Not complete.
Schedule B property we have not given you.
What is the impediment for issuance of non-due certificate? That is it.
That I'll give in my reply, my lord.
Non-due certificate.
At least at this stage, notice should go, my lord.
And
I will file my reply.
Objection, reply, objection, affidavit objection.
The IA number so and so, this is an application filed under Order 627 of CPC. The copy of the amendment petition has already been served on the
On OP 1 and 2 for the bank.
council for the opposite party number 1 and 2.
For the bank, my lord, both.
Okay, Achandi.
3 आगे सब रजिस्टर 4 by lordship's order he should have made been a party in consolidated constitutive तम देई ना अंतिम कोई period
1 and 2
and 2 after hearing the land council for the both the parties and going through the amendment is allowed. The consolidated, you have filed the consolidated.
Yes.
My lord, I will file my objection, my lord. My lord, at least a week's time may be given, my lord, to file my objection. Amendment to
who is that opposite party you are saying?
Opposite party number 4, my lord. He should have made him a party.
No, he is yet to be.
So and so submits that Subrot Kumar Pal is a necessary party for which notice IA is this IA is disposed of and consolidated. That is copy be handed over to the land council for the bank, which is party number.
Already filed.
No, consolidated.
देखो तो page chapter चुप consolidated prayer दे दीजिए.
Consolidated flag is there.
My humble submission, kindly have a glance. There are objections, page 7. Kindly have a glance.
No, now the matter is to be heard on merit.
Lord, I have to then file my objection. I have to file.
I am
to the writ petition as it stood before the amendment. I have filed my reply. Yeah, my lord, I have to bring those things on record. My lord.
The bank submits that since amendment has been allowed, you want to file supplementary counter objection to the writ petition, and he may be given some time. This matter will be commencing from 2nd of September 2020. Yes.
My respect, I am petitioner in this case. The sole issue involved in this writ petition. मतलब अकाउंट क्लोज कर दियो ना कि सेटअप है तो किसी असुविधा नहीं मोर अकाउंट मु अकाउंट लोन पाउन ना गया अकाउंट क्लोज करू ना अकाउंट नो ड्यू सर्टिफिकेट दियंतु टका गोटे भी बाकी नहीं नेक्स्ट केबे को रखले सर
item number 14
where is 2nd September
2nd September
earlier 27 को रखो तो यार
we have already fixed so many cases on the 27th. Yes, next.
Item 30
minus item 40.
Item 40, I am the petitioner, madam. It was the crux of the matter, my lord.
Before my lord hear this, my lord, I am seeking an adjournment on behalf of Satyas Murthy Mohanty. I am preparing for the opposite party. We are seeking a short adjournment. He is actually out of town.
But you are challenging the order of the cat.
My lord, the opposite party number 1, my lord. was proceeded for receiving gratification. Receiving gratification of 1,000.
Okay.
Then criminal case was instituted against him, so also disciplinary action was taken. And in the disciplinary action matter, punishment was imposed before judgment in the criminal matter. So he was imposed punishment of the page number. Annexure. At page 200, it starts the punishment order. And page 220, para 9, madam. Just a minute. Now, therefore, the President, after giving careful consideration to the charge memorandum, inquiry report, the recommendation submitted by the Dr. S.N. Behera, thereafter, such and such, and lastly, if a penalty of withholding of 100% of his monthly pension is imposed on him on permanent basis, further the entire gratuity admissible to the said Dr. S.N. Behera may also be forfeited. This was the final order, man. It was assailed before the London Tribunal, and London Tribunal, madam, hold that there is no violation of natural justice, and opportunity was given to the delinquent officer in participating the proceeding, madam. And the London Tribunal, my lord, dismissed the original application, which was assailed before this honorable court. And this honorable court, my lord, had order dated remitted back the matter to the London Tribunal as because Rule 105 was not complied with. As because the judgment was to pronounce within 3 weeks, but was pronounced after that. So, this honorable court remitted back the matter to the London Tribunal for fresh adjudication.
Yes.
Basing upon the documents which were earlier, no fresh document will be added. Which were added before, basing upon that document, fresh adjudication will be made. And what my lord London Tribunal did, this time he allowed the vote. That he allowed the original application, holding that there is violation of natural justice. So, on the ground that, my lord, when the final punishment was imposed upon the delinquent officer during the disciplinary proceeding, the London Tribunal hold that the advice of the OPSC was handed over, was supplied to the delinquent officer with the punishment order. So, you must have sought the advice of the OPSC much before imposing the punishment. He hold and allowed the way being violation of natural justice. Our humble submission before this honorable court is that in the earlier judgment also, the London Tribunal hold that the delinquent officer no way it doesn't cause any prejudice to him. He was sufficiently given opportunity, and he also didn't raise any
this plea was not raised. This plea was not taken.
No. So that's why we have come before your lordship challenging the tribunal's order. And at annexure 6 series, I have annexed that order on the same issue. Whether the advice of the UPSC is we have supplied that advice to the petition. Not that it is not the case of the petition opposite party that he has not sought the advice of the UPSC. We have sought the advice of UPSC, but along with that, the final order. So on this point, my lord, issue is pending for the Honorable Apex Court. I have annexed that order at Annexure 6 series, my lord. And the matter was, notice was issued and it was pending before the Honorable Apex Court for adjudication on this issue, my lord. So, my lord, in the meantime, they have filed the contempt petition before the CAT. So that
Content petition why they filed?
For non-implementation
of that order.
Yes, ma'am. We have approached this honorable. So,
What happened to ultimately that criminal proceeding?
But criminal proceeding, he was acquitted.
Okay. There is no challenge to that acquittal order.
Well, that perhaps will not challenge.
Okay.
I will also take on that point instruction.
So now, suppose somebody is facing two proceedings, one in the criminal court, other in the disciplinary proceedings. And disciplinary proceeding, he is found guilty, and in the criminal proceeding, he has been acquitted, and that acquittal order is not challenged. Then what would happen? It would be a result of that disciplinary proceeding that has been decided also by the Honorable Supreme Court.
Yes, ma'am. In Rampal's, in the case of Rampal, I have also got that order. I will go through that order. Recent case 24, Rampal Singh.
So
he has also that order. Last occasion.
So that is why we asked you that what is the result of that and whether you challenge it or not. You said no.
So I will, perhaps it was not challenged.
Just take instruction. It's a legal point. Whether that would have any effect at all or not. That has been decided.
Yes.
So he is seeking for adjournment.
Yes, ma'am. Short adjournment. And my humble submission that on 26th that contempt they are pursuing. Contempt that may be stayed. Contempt proceeding the stay. I am not seeking for stay of a judgment. Till that date, at least.
Yes, what do you say?
I object to the prayer just now been sought by the petitioner. With all due respect, I was honorably attending the bill case. The inquiry officer in the second, my second form of adjournment is the inquiry officer did not provide all the necessary documents to me during the
counsel. Are you ready to argue, or in the first instance you said that please adjourn the matter? That is why we thought that you are seeking for an adjournment. Yes, but again you are starting to argue the matter. So either you argue or seek for an adjournment.
I seek for an
the learned counsel for the opposite party seeks for an adjournment. The learned counsel for the petitioner, Union of India, has placed the interim application which has been filed and been numbered as IN number 4282 of 2024 and submits that since the case, this contempt petition has been filed before the Central Administrative Tribunal for violation of the order dated 11/5/2020 passed in OA number 105 of 2015, which was filed by the petitioner. That was filed by the petitioner. And till next date, the contempt proceeding, the court may be directed not to not to proceed with the contempt proceeding. In view of the submission, the Central Administrative Tribunal is directed not to proceed with contempt applications 1-63 of 2022 till next date, which is fixed to Gordiondu. It will come commencing from 2nd September 2024. The अच्छा एक गोटे line लिख दियो. It appears that uh, the case was registered against the opposite party by the CBI for accepting illegal gratification, and he faced trial in the court of London Special Judge CBI Bhubaneswar. And on the self-same allegation, memorandum of charges were served on the opposite parties, and an inquiry was conducted, which resulted in passing the order of what order was passed final?
Final order.
Final order.
Punishment.
Punishment was imposed. However, it is brought to our notice that the London Special Judge CBI Bhubaneswar has acquitted the opposite party of all the charges as per judgment and order dated 27/12/2012. And the London Council for the petitioner submitted that he has instruction that there is no challenge to the aforesaid acquittal order.
I'll take instruction.
Boile pranay. 12 वर्ष ହେଇଗଲାଣି 2012. We are in 24. So the counsel for the opposite party 6 times is related to address whether what would be the effect of the order of acquittal on the result of the departmental proceeding. That is for the property. So that's all.
Well, item 52, my lord. As I say, item 52.
Yeah.
It may be fixed too because they have not solved the copies of the counter, my Ajit. So let it come on. We commencing 9th.
Not solved.
In the note sheet of the counter itself, that was item 52.
State is the other side.
State is the other side, also MCL. MCL state. They have not.
No. Opposite party number 3 and 5.
Government parties.
They are the
government parties.
Okay. Three is collector and district magistrate Asura, and 5 is sub-collector. So counter affidavit has been filed as it appears from the first list. So why don't you solve a copy on this? Item number 52, the London Council for the petition was submitted that the counter affidavit filed by the opposite party number 3 and 5 not installed on the Land Council for the petition, and during course of this week and installed on the Land Council for the
and the MCL also 7 and 8.
7 and 8 which is not a police. 7 can appear question. 7 the counter affidavit.
We're missing 9, man.
Lord, item 42, my lord. I mean VC, my lord. The counter not filed with 42 counter. Even though your lordship on 8/2/2024.
Hmm.
42.
Say staff of the High Court.
No, my lord, the staff of the Kalandi Joseph stenographer.
It is no stenographer. Stenographer.
No, we have received a Parav's comment. We'll make a 42, madam.
For the street survey that there's already the Parav's like the counter
Please time.
Since the recovery is going on, my lord, I filed for IA. The lordship after instruction, the recovery from my salary they are continuing, my lord. As for annex. Annex 12, page 89, my lord. That might further recover.
My lords, item 44, my lords. We will file a rejoinder to the counter affidavit received by the bank, my lords. I pray an adjournment may be given for 1 week's time. We will file the rejoinder.
Next week.
Item 43.